Those of you that are familiar with our work will know that we have been tracking the growing presence of equity, diversity, inclusion and its underlying moral, political, sort of ethical premises for quite a while now. We've been looking at it in terms of local authorities and particularly in schools and education. But what struck us during that process was that we weren't quite hitting the right level, that the policies themselves, it was very easy, and I don't think this was a sort of, manipulative thing. I think it's genuine on the part of a lot of people who would say, well, we've got this policy, but nobody listens to it, right? We just ignore it. It's just there in the file. And yet their conduct, their practices were embodying the very beliefs of critical race theory, even though nobody has read Ibrahim Kendi or Robin DiAngelo necessarily. So we thought, well, there's something is going on here that we're not quite getting at. There's a kind of norm, a new norm of everyday conduct that is coming from somewhere. Now, I've never been a believer that ordinary people get up in the morning and read the law and go out and behave according to the law. But an act like the Equality Act is particularly unique in its reach and spread, and perhaps that'll be something we can talk about. It's, I think, quite distinct from other legislation, particularly prior anti-discrimination legislation. And I think the Act is, in the conditions of today, the specific political and cultural conditions of today, the Equalities Act is scaffolding, it's allowing legislative framework that is really facilitating, if not directly causing, it's encouraging a lot of the behaviours, a lot of the conduct, a lot of the changing norms that people are finding in their everyday workplace, not for the better. So that's really what prompted us to have a look at this report, and we thought that actually it was litigation that was the level that you could see, because this isn't people making a rhetorical statement. This is people taking time, effort and energy out of their lives to pursue a course of action that leads them to the courts. And for both employee and employers, it's an awful lot of energy expended in that process, almost irrespective of the verdict. So the process is the punishment in a lot of ways. Anyway, we're going to have this discussion. First of all, before I introduce my wonderful speakers and co-author of the report, I do want to thank people. I want to thank the Institute for Policy Research who kindly funded this research. I want to thank Ben and Jeremy and Leo and people who have sort of really helped us in allowing us to use this lovely venue. And I want to thank my husband, who's lived with me and the Equality Act for a year. It's been a ménage à trois of sorts. And I want to thank all the people that I've had discussions with, the wonderful advisory councils, colleagues like Joanne, people who've worked on who've really helped us work, help with the research. I never imagined we would spend so long inputting over 5,000 tribunal case hearings. I literally thought at the beginning, it'll be a few hundred, we'll get that done in a week or two. It took months. It was the most painful thing I've ever done, and people here will testify to that. But anyway, let's push on. The format will be a kind of conversation between us three for about 15-20 minutes, and then we really want to hear your questions and points as well and have a conversation, take a few and then come back. And I want to introduce my wonderful co-author, Anna Loutfi, who is a employment specialist barrister and a human rights barrister.
Yeah, human rights.
But don't hold that against her. She's really lovely. And she's co-author of this report. I think her section is fantastic in the way it really, I think, allows people in an accessible language to understand the history and jurisprudence of the Equality Act and get a flavour of why it is different to previous legislation. And then to be our interlocutor, our questioner is, we've got wonderful Tomiwa Owolade, who is promoted to assistant editor at comments editor at the Telegraph, and is a writer himself and has followed these issues, I think, for quite a while. So we hope you'll enjoy the evening. Please do take a report. In fact, take lots of reports. Do hand them out to people. We really want it to be it's great, it's got coverage and a lot of press. My most, if you like, thing I'm most delighted about is that Personnel Today have covered it. to have somebody from the profession itself cover it is for me quite delightful. So I hope you'll spread the word. Okay. Thank you.
Thank you. Thank you very much. My first question is for you, Alka. In what ways is the 2010 Equality Act different from the 1965 Race Relations Act?
Okay, that's the main difference, I think, between the 65 Act is that the 65 Act was dealing with a set of issues, one of which was a concern on the part of the political elites for race relations with the growing coming immigrants from the Commonwealth who were coming in at that time. That was in the context where there was, a limited rise and presence of right-wing groups in certain parts of London, in part of the country, but it was by no means generalised across the whole nation. And it was also, interestingly, and I never knew this until I looked through Hansard to read the discussion at the time, which I really recommend. Hansard is brilliant. It was actually incorporating part of the Public Order Act, the pre-existing Public Order Act. And the discussion was fantastic. I mean, you do not see those kinds of political discussions in Parliament today, because the Conservative criticism of that, the Race Relations Act, was that by being a Public Order Act, it was immediately putting putting the whole swathe of people under a shadow of criminality for speech, for potential speech, which had never been done before. So there was that part of it, but the overall, I think, paradigm of that, the 1965 Act, was, if you like, the ethical principle was that we're a democracy, we believe in equality, we want people to be treated fairly. It is very possible, it is very likely that there are people who belong to who are immigrant groups who are not being treated fairly, and we want to address this, and we want also, if you like, to make a symbolic gesture so that everybody knows this is not acceptable behaviour. And the idea was that these people would be given equal rights, they would be treated equally in areas of public life, so that they could participate as British citizens alongside their fellow citizens. So it was aimed at individuals, it was aimed at uplifting people to a plane of equality with their peers.
Sure.
Now, and it was focused on individual discrete acts of discrimination that were describable in objective terms. The Equalities Act is really quite a fundamental paradigm shift, because it calls itself anti-discrimination, and it's presented as a bundling up of all the pre-existing anti-discrimination law, which at that time would have been sex, disability and race. And it's like, when it's true, there were a lot of pieces of legislation and amendments, and they said, let's just tie it up together and, make it easier. Anyone that has any experience of administratively trying to make things easier in that streamlined way will probably know it backfires very badly, because it's in the all what seems messy is where all the kind of nuanced judgments are. What happened with the Equalities Act was that it then became not about sanctioning or disciplining acts of discrimination. It became about a positive duty to promote equality and advance good relations between people, which is, I would argue, a carte blanche for the state to regulate relationships.
Anna, in what way does the Equality Act curtail freedoms and regulate relationships?
Well, I mean, I think what Alka was saying about the debate in Hansard that took place, where conservative voices were objecting to the potential criminalisation of speech under the guise of instilling a new social landscape based on racial equality or anti-discriminatory law, is the first step in answering that question, because of course much of what we do as human beings is self-regulating, and whether we like people's speech or whether we feel in personal interactions with others, whether it be in the public domain, for example at work, or in private interactions in the pub with friends. We do a lot of self-management, and we do a lot of self-regulation, and we will make executive decisions about who we're prepared to interact with and on what terms. And what I think Alka is trying to say is that the instilling of a discourse that engages the public order offence and criminalises behaviour because it's seen as racially inflammatory, which could be just speech, requires a whole rethinking of civil society where people are no longer adjudicated by the elite as capable of self-regulation. So where you might have, for example, a playground scenario where a child is being singled out, and the teacher's job is to integrate the child that's being singled out for whatever reason, ginger hair, black skin, it could be anything. There's a certain responsibility that is handed over to the school in question, and there's a certain maturity that is attributed to the teachers in charge of the children. And there will also be a presumption of maturity within the student population of that school, in that they have to also understand why certain things are not considered to be appropriate or helpful.
Sure.
And that sort of micro management of everyday life, which has been traditionally outsourced from the state to the people, with the state having on the surface of things, at least nominally, at least performatively, in a liberal democracy, a sense of its own limits and a sense of where it should not go. And that's what liberals have traditionally talked about when they talk about the private sphere or the family. That becomes a very easy infrastructure to dismantle in the name of promoting anti-discrimination and anti-racism. It's the private sphere that takes the first hit, and with it, the ability of human individuals to self-manage, self-regulate in terms of their ordinary interactions with others. And if you look at something like Section 26 of the Equality Act, which is the clause that deals specifically with harassment, and harassment can be related to any protected characteristic, it doesn't confine itself to race. But much has been said, at least in my profession, about the broad nature of the test for harassment, whereby, and Alka covers this in the report, whereby the Equality and Human Rights Commission guidance on harassment will invite employers and employees and members of the public and politicians to consider every single gesture, word, every possible interaction between two human beings as potentially harassment, if the subjective part of the test is fulfilled, which is the perception of the complainant. And then it'll be for a judge to introduce objective tests and say, well, was it reasonable in the circumstances of this particular scenario for that person to feel aggrieved? But in principle, it is the subjective perception of the claimant that takes us over the line into the domain of harassment. Now, of course, under the Equality Act, harassment is not a criminal offence, but you can see the conservative reservations that were being voiced about the Race Relations Act in the 60s and 70s coming into play again in the civil sphere, in the civil domain of the workplace, where if you say something or do something, potentially you may be engaging in a gesture that is perceivable as harassment. And we have cases, some of them chronicled in the report, but I mean, anyone who works in this area in terms of their general practice will tell you that gestures that can be configured as harassment may on the surface have absolutely nothing to do with race. And I gave an interview yesterday to Sanchez Manning from the Daily Mail, and I gave the example of the gentleman who said to a colleague at work, "What have you been smoking?" Because he said something that was considered to be outrageous or silly. And the reference to marijuana and the fact that the gentleman concerned was from an ethnic minority background, I think Jamaican possibly. That was a sort of perfect storm that lends itself to become a harassment situation, which has quasi-criminal implications, of course, because we're now living in a society where, civil speech that breaches civil rules can potentially go into the public order domain very quickly, and we find people now in prison for tweets and so on and so forth. So you can see how the freedom situation, your question was about freedoms, is quickly engaged when you start to micromanage everyday ordinary interactions and give people no responsibility for taking on the implications of those interactions for themselves.
Thank you.
Very long-winded answer. Sorry about that. I'm very tired.
Great answer. Alka, what exactly is the public sector equality duty, and why is it so dangerous?
Well, I think really, and as a kind of answer to that, really, it's a duty to promote to foster good relations. It's to, there are three prongs to it. It has to advance equality, it has to eliminate discrimination, and it has to foster good relations. I mean, who is going to define that? That is just everything. I mean, equality is, equality, it's like a standard that you work towards. It's not something you're ever really going to reach unless you're in a completely authoritarian society, because you're always going to have to allow for individual free will, individual choice, individual circumstances, and the way individuals make sense of their circumstances in relation to their own particular, state of knowledge, beliefs, ethics, etc. So advance equality. It's far too general, and with no limits at all. And that is what is causing a lot, so much confusion. If you take the media discourse, it does seem like it's just all a case of either grifters or horrible systemic racists. But the reality isn't that. And, in our report, having looked at over 5,000 cases, you can see there certainly is that in some cases. But the majority of cases are not that. The majority of cases, I think, is something much more disturbing, actually.
Yeah. Can you give some examples?
Yes, I can. I mean, I'll give you a very good example. I'm just going to refer to because I haven't got it all in my head. But there's a very famous case. I say famous because it's quoted a lot by solicitors and barristers and by third-party organisations. And it's of, where is it now? Zweyama, I think, is the lady's name. She was worked in the NHS, and anyway, it's quite an obviously egregious, the egregious case. What was said to her was horrible, right? She was a black worker, and she was working, and she's an NHS worker, so you have in your mind an image of an NHS worker in an NHS situation, but she was actually working in one of the centres at Heathrow where immigrants are kept before being deported. IRCs, I think they're called, or something like that. And so you can imagine that's going to be a high-stress situation. And there were a lot of, I think, East Europeans in at that particular time who were chanting racist things at her. In actual fact, what had happened before that was that the number of Albanian inmates or patients, they should not have been in that room, right? The protocol was breached, and there were so many of them in that room all chanting at her. Had the protocol been observed as to how many people could be allowed at one time, that may not have happened. So that's step number one. She decides to report it. No, first of all, she says no, she's not going to report it because somebody asked her, says, you must be upset, do you want to report it? She says, no, it happens, it's not uncommon, just get on with it. However, in the subsequent day or two, she revised her view and decided to report it on a computerised system. However, the computerised system was for complaints of a more administrative nature and for complaints for workers not like her, because she was an agency worker working at that NHS institution. the computerised complaint system was for people working directly for that institution, but nobody knew. Combined to that, the people who were meant to be monitoring that were off on long-term sick leave, so they didn't pick that up, right? So there's this chain of things that happened before that, and then it got to the point where she then, she was so fed up waiting for a response because nobody was responding to her complaint, and said she was going to go off sick, and her line manager, who was also East European, who she had been good friends with, they had been friends before, said to a colleague, not directly to Mrs. Wayama, said, well, she should, I'm fed up with people going sick, Basically, she was expressing her frustration at the overload, at her work overload. She said, I'm fed up with people going off sick. She should just go home and bleach her skin, right? Which is an absolutely awful thing to say, right? However, she, and so eventually it went to court, but it didn't really go to court for that particular, the main thing was not what was said. The main thing was that after that, she then did go off sick, and then when she came back, she wanted to work at another centre, and her line manager went to visit her when she was off sick to ask what was wrong. That was seen as harassment, right? Because she was off sick for a racial. She was off sick because of what had happened that was race related, and the manager had gone to see her, and it was deemed by the judge that the manager in going to see her had done it to try and dissuade her to come back because of her race. That was, so, I mean, what do you do with that? How, on earth, these are not matters for the court. The court is a blunt instrument when you're dealing with that kind of scenario, and there are so many things that need to be looked at and addressed in a situation like that. But instead of which the race discrimination element of it under the Equalities Act is being used to both sort of inflame the emotions of it all, but also to obscure the real problem. The real problems are not being looked at.
Anna, if we get rid of the Equality Act, should we replace it with something else?
I knew you were going to ask me that. I don't know.
The Race Equality Act, maybe.
I mean, look, it's a cop-out answer, but there has to be a conversation in order for us to even start to appreciate the logistics of removing what has become an incredibly... what's the word you use in the report? You have a word where you talk about the Equality Act as sort of its spread and its embeddedness in everything, and I can't think of the word right now, but it has this capacity, and I think it's a special feature of the Equality Act. I actually describe it in the report as an assistive technology rather than a law, because it's a way of disseminating a regime change or an attitude change, or if you like a political ideological shift that is supposed to be embedded in all of our institutions, increasingly I would say even the private life, and it expresses itself as a kind of as a generic set of positive duties which people are then left, usually people in authority who haven't got a clue about anything, to sort of implement policies that seem to reflect the general tenor of the Equality Act. And for that reason, the Equality Act seems very all-pervasive in our society. It is certainly pervasive throughout the employment tribunal world. Equality Act claims are brought routinely now, often to bolster and to enhance and to strengthen claims that are not necessarily protected characteristic related, ordinary claims of unfair dismissal, constructive dismissal, and you'll chuck in an Equality Act claim as well for good measure. And so what we're seeing is this seeming all-pervasiveness of the Equality Act. And one of the side effects of that is that it seems almost impossible to imagine a world without it, particularly if you work in employment law. You think, well, how on earth would we have any of the discussions and deliberations and judgments that we now have without the Equality Act, because the Equality Act is the go-to kind of Bible.
Yeah.
So when people ask me, well, how can you just get rid of it? I think the answer to the question is, well, just because it's pervasive, and this is going to sound strange, doesn't mean it's real. Because so much of our report is trying to track the way in which cultural and political shifts in the zeitgeist lend themselves very well to the Equality Act, and the political ambitions of the Equality Act lend themselves very well to shaping the cultural zeitgeist, we should not therefore be fooled into thinking that either the cultural zeitgeist and the political objectives of the European directives from whence the Equality Act came are immovable feasts. They're simply not. Cultures change and discussions can shift those cultural normative assumptions. One of the things I think we need to do, I said it was a cop-out, but if starting a conversation is a real practical step forward in thinking about alternatives, one of the things we need to do is ask ourselves, what the hell is a protected characteristic? Because it is not clear, and I've been working in this area of law for many years now. It is not clear to me exactly what the authors of the Equality Act think a protected characteristic is. What Parliament intended by ratifying the Equality Act in terms of bestowing these protected characteristics in codified form on British society, it is certainly not clear that HR departments and employers understand what a protected characteristic is, and ordinary members of the public, including employees bringing claims in the employment tribunal, do not fully understand what it is. And you will hear people make all sorts of claims about protected characteristics. I mean, we saw this with the transgender debate. The protected characteristic was gender reassignment, and then it was trans, and then it was transgender, and then it was LGBTQIA+, and you know, and everybody was sort of putting this concept of the protected characteristic at the door of whatever framing that policy was imposing. For example, in the context of race, BME or BAME was for a time, I think it's waning now, but it was for a time the policy catch, an acronym, and that was very much treated by people in charge of employees and workforces as a protected characteristic. But of course it isn't, because if you're not BME, whatever that means, of course you already are also protected racially from discrimination. So you can see how we need these conversations and in order to start thinking about a world beyond the confines. It's a bit like being gaslit. We've been gaslit for many years now, and I think we need to start by saying, what is a protected characteristic? My money's on the people in power not being able to answer that question. If they can't, then it has to go as a system of codification.
Do you have any questions?
Sorry, can I just want to go out in a minute, sorry, just a really quick thing on that. Lizzie, I think, I mean, because this is a discussion I've had with some gender critical feminists who have said to me, what is your objection? Because we are all equal. Everybody has a sex. Everybody has a nationality or ethnicity. But the point is that this is a kind of more, I suppose, of a moral or an ethical point. Was that under, if you like, the established democratic, liberal, or social democratic legal paradigm, if you had a grievance, you presented yourself to the court as an individual citizen of a nation state, and you were drawing on the nation state's legal provisions, which would be applied universally. The Equality Act, as you said, everybody's got an ethnicity or a sex. You present yourself to access the nation's legal resources, not as a national citizen, but as a member of a protected group. And the universality of the application of the law is so porous for all the reasons, you know, its genesis and the influences on it, that it's very open to outside social and political pressure, which, as we know at the minute, is dominated by identity politics. So we are all in groups, but not all groups are valued equally in the law. In a way, I'm thinking it's actually a legal expression of a multicultural state,
Mm.
the political multicultural state.
Yeah, great, thank you.
And just to add to that, we've got also things
And then
like...
we're going to go to the audience in a minute.
We've also got, for example, Muslims claiming religious and race discrimination simultaneously for the same acts complained of. So it's again, if you look at the definition of religion alongside belief in the Equality Act, which is protected, that's about belief systems that you adhere to as an individual. But of course, with some belief systems, that is also racialized. But it's not clear to anybody at this point why Judaism and Islam are racialized, but Christianity isn't. And other belief systems like Scientology, for example, aren't racialized, or Jehovah's Witnesses aren't racialized. So you can see again that it's messy, and it's not. If it's not clear to the people who've drafted the law into existence, then I think it's very unfair to impose it on the rest of us.